I knew I had read this so many years ago, and sometimes your mind starts playing tricks on you. But I remembered. I was sitting on the toilet and I remembered. You guys need to go look this up. This I found on Wikipedia, the free encyclopedia. This is Nunn versus Georgia. 1 Georgia, 1 KEL 243, 1846 is a Georgia Supreme Court ruling that a state law ban on handguns was an unconstitutional violation of the Second Amendment. It was the first gun control measure to be overturned on Second Amendment grounds. I better back this up just a hair, guys. In 1837, Georgia passed a law banning the sale and carry of certain types of weapons, including Bowie and other types of knives and pistols. Hawkins H. Nunn was charged and convicted for carrying a pistol in violation of the law. He appealed the ruling, claiming the state law was in violation of the Second Amendment to the United States Constitution. He did not make a claim under Georgia Constitution because Georgia, unlike many other states at that time, did not have a similar protection of the right to bear arms within its constitution. So it says here, we are on the opinion then as far as the Act of 1837 goes, who suppressed the practice of carrying certain weapons secretly, that is valid inasmuch as it does not deprive the citizen of his natural right of self-defense or his constitutional right to carry and bear arms. But so much as it contains a prohibition against bearing arms openly, it is in conflict with the Constitution and void, and that the defendant has been indicted and convicted for carrying a pistol without charging that was done in a concealed manner under the portion of the statute which entirely forbids its use. The judgment of the court below must be reversed, the proceedings squashed. In other courts, now this is a little bit later, the Nunn Court reversed the Bliss Commonwealth 12 Kentucky, 1822. The state versus Reed, 1 Alabama. The Bliss defendant was charged with carrying a weapon concealed in violation of Kentucky statute. The Bliss court invalidated the law as a dominion of the Kentucky Constitution, which provided the right of the citizens to bear arms in defense of themselves and the state shall not be questioned. The court reasoned that the right as defined has no limit and in fact consists of nothing else but the liberty. Any restrictions on the right, including their prohibition of concealed carry, was a violation of that right. In contrast, the court upheld a similar ban on concealed carry. The Alabama Constitution that every citizen has the right to bear arms in defense of himself and the state. The Reed Court held that the law to suppress the evil practice of carrying weapons secretly did not violate the Alabama Constitution. While the legislature could not prevent the carry of arms, it did retain the right to enact laws in regard to the manner in which arms shall be borne. Because the restriction of concealed carry was not a prohibition on that right, it was within the ambit of the to restrict carry. Says here, it's true that adjunctions are all made now. Adjudications are all made on the clause of the state constitution, but these instruments confer no new rights on the people which do not belong to them before. When I would ask, did any legislative body in the Union have the right to deny its citizens the privilege of keeping and bearing arms for their country? No. The court held that the Second Amendment to the United States Constitution protected the rights of Georgia citizens because the free people have the right to self-defense. The fact that Georgia did not have a constitutional amendment which empowered the Georgia Constitution to infringe on that right, the right is a fundamental, and no free society could exist where that right is prohibited. The court also held that the whole people, not just the militia, were afforded the right to keep and bear arms, and that type of arm was not restricted to those only borne by the militia, but every arm and every type in the description. The right of the whole people, Old young men, boys, women are not the militia only to keep and bear arms of every description. It is not such merely as used by the militia shall not be infringed, curtailed, broken in upon in the smallest degree, and for that the important end to be attained, the rearing up and call upon a well-suited, well-regulated militia so vitally necessary to the security of a free state. The court's concept of rights meant that the other portions of the Bill of Rights would also apply to the states. For example, the court explained that the right to peacefully assemble, protected under the First Amendment, was applicable to both the national and state governments. The court also cited the New York case of People versus Goodwin, which applied Fifth Amendment double jeopardy prohibitions to New York court operations. The court explained how to determine which Constitution provision applied to the state and which applied only to government. The relevant question is whether the concepts in the Constitution were confined only to national government or could they be extended to the states. These general comprehensive expressions extend the provisions of the Constitution of the United States to every article which is not confined by the subject matter to the national government and is equally applicable to the states. All you have to do, people, is look up, what was it? Brain dead. Marbury versus Madison. And it says there that the Constitution is the supreme law of the land. Now, I want you people to look at this. I want you to go over it. I want you to use it. I'll put the link in below. I want you to go look at it. I mean, this goes way back, people. And for these people, 100 and some years later, decide, well, we want the people's guns. No. No. A free people is allowed to have firearms. Socialists are not. Thanks for watching.